Hello, everyone. Well, there's sovereign citizens and there's sovereign citizens, isn't there? I mean, sovereign citizens, they're just like the flat earthers of the legal system or something. But when I say there's sovereign citizens and then there's sovereign citizens, what I mean is there's this woman who's just like the most narcissistic, entitled, disrespectful, arrogant, she bully that you've ever encountered in your life. You have to check this woman out.
People versus Zoe Galloway, 25T 3675. Ms. Galloway appears in person. Good morning. Let's see, Mr. Contreras appears on behalf of the prosecution. I am a senior judge, Ms. Galloway. Judge Meyer is in a 3-day trial, so I'm just helping her out with her dockets, and she was unavailable today. We didn't want to continue these matters. And give me 1 second here just to find your file. So I see that the case is 101 days old. You last appeared in court on December 11th. And looks like you did not want to fill out an application for the services of the public defender's office, and you did not want to speak to the prosecution. Is that right?
Well, first of all, I'm here on special appearance.
I don't know what that means.
Okay.
You're not here on a special appearance. You're actually here on a summons.
Okay, I want to jump in there. Obviously, it's going to be obvious to, clearly it's going to be obvious to everyone, like the judge and everyone, court staff, etc. So if she wouldn't sign up for a public defender, that tells you straight away that she's this full of herself, I can represent myself type. But then after that, if she wouldn't speak to the prosecution, who does she think it is that's going to make some sort of agreement or deal for her? Of course, she doesn't think that. She just thinks that she's going to waltz in here and just tell them all to go away and leave her alone because, I don't know, she's amazing or something. Or here we go.
Issued by...
I am here on special appearance. Okay. And by the way, I also filed a notice of presentment. Unfortunately, it was sitting in the mailbox for about a week.
I don't know what that means.
Okay. Well, it's a conditional acceptance offer.
I don't know what that means.
Okay.
Nobody does.
Well, the prosecuting party has not yet established mens rea, actus rea, corpus delicti, and...
Okay, so we can assume from this straight away that she's gone out, she's bought herself a copy of Black's Law Dictionary. She thinks that that's law, so if she learns a few of these terms, that she knows all about the law. It's just a dictionary.
Or provided any proof of an injured party.
That's why we have trials.
Okay. Well, they have to do that in order to establish subject matter jurisdiction.
Okay.
They don't have to do anything for you. See, this is where these judges, they pussyfoot around. They shouldn't do this. They should just jump straight in and say, look, let's come to an understanding here. You've received a summons. You've been summoned to come here. As part of this process, you're probably going to have to enter a plea. So this isn't a situation where you come and make demands. You use the word acceptance, where you believe that you're in a position where you accept things. You're not here to accept anything. You don't have a choice in all of this. It's not by your consent. You're not here by special appearance. You don't define what you are when you come here. We define what you are. The court defines what you are when you come here. You're a defendant. You've been summoned here to defend yourself or have someone represent you to defend you and make pleas. And to put it in basic layman's terms, you're answerable. You're under the jurisdiction.
So sounds like we're going to set this case for trial today.
Okay. Well, I will only conditionally accept if the prosecuting party develops subject matter jurisdiction. It is officially being questioned, so they have to develop that, and they have to, present actus rea and mens rea.
Yeah, I heard what you said. My question to you is, how do you wish to plead, guilty or not guilty? We're setting this case for trial today.
Okay, so I have a conditional acceptance.
I don't know what that means. All I'm asking you is, how do you wish to plead? If you choose not to answer my question, I'll just enter a not guilty plea on your behalf.
Okay, so
So she's not listening there. If you choose not to answer, I'll enter a not guilty plea on your behalf. They're not listen. They're just not listening, are they?
Well,
How do you wish to plead?
I will only conditionally accept under the conditions that the prosecuting party within the next 14 days is able to establish all of these
I'm
elements.
denying your request, and I'll enter a not guilty plea on your behalf since you're refusing to do so on your own behalf. And so this is going to be a one-day trial. The trial will commence on
March 25th at 8 a.m.
March 25th at 8 o'clock in the morning.
I mean, he's good so much as in that he's not entertaining her rubbish or listening to it for too long, well, at least not at this stage. And he's not reacting in any kind of emotional way to it. But my argument still is that it's just allowing them still to believe that they're in charge, just ramble on, just keep wasting the court's time. I think part of the being answerable process when you appear before court as a grown-ass adult is that, there's some measure there where, sure, you need to be respected as a grown-up, but you also, these people that behave this way need to be put in their place, and their disruptiveness and their obstruction needs to be nipped in the bud so that it just doesn't waste 20 minutes of the court's time.
So I want to point out that I am
I'm not finished talking. The
So
pre-trial readiness-
I am the only injured
I
party in
am
this
so sorry,
case.
but when I talk,
So-
you don't. When you talk, I don't. The pre-trial readiness conference will be on.
19th at 2.
Okay.
Are you a neutral judge in this matter?
Am I what?
A neutral judge in this matter? Or are you
A
on?
neutral judge?
Yes.
I don't know what that means.
You know what neutral means?
I don't know what you're asking.
Are you on the prosecutor's side or?
You don't know what neutral means. That's the thing, isn't it? You see in these cases where the judge says equity claim, like she's going to do here. She's going to claim equity, and the judge will, because it's a criminal matter and nothing to do with contract law, they'll say, I don't know what that means. I don't know what that's referring to. I'm trying to dismiss it that way. And the sovereign citizen goes, aha, it's a gotcha. They don't know what a word means that I know what it means. That's not what's happening, Flopsy.
I don't know what you're asking.
Are you on the prosecutor's side or are you neutral in this matter?
let's
Or
go
are you
back.
on?
Neutral judge?
Yes.
I don't know what that means.
You know what neutral means?
Don't know what neutral. It's pathetic.
What are you asking?
Are you on the prosecutor's side or are you neutral in this matter?
I am not a prosecutor. I'm not a defense attorney. I'm a senior district court judge assigned.
Are you on the prosecutor's side or are you neutral in this matter?
I just answered your question.
You did not answer my
Okay.
question.
Well, if you're not satisfied,
It's obstructionist because any grown adult knows that the judge is meant to be there as the neutral arbiter of both sides. It's just this attempt to try and find a way to accuse the court of being corrupt or biased against them in some way.
I'm sorry. The motions hearing will be on March 10th at 2:30. The motions hearing will be on
February 27th
at 11.
So be aware that I placed a bond on this matter and a notice of presentment.
Okay, thank you. And so let me just recap what we're doing. We are having a jury trial. Right now you are presumed innocent, and it's the prosecutor who has to prove actus reus and mens rea and all of the elements for the crime that you're charged with to a jury of 6 unanimously beyond a reasonable doubt. That trial will be conducted on March 10th at 2:30 in the afternoon. That trial will be on March 25th beginning at 8 o'clock. We're going to have a pretrial readiness conference to make sure the parties don't have any last-minute issues. That'll be on March 10th at 2:30. I'm setting a hearing on February 27th at 11 o'clock for any motions that need to be resolved.
Last minute issues and all of that. That'll be a for sure. I should have stopped there and said that, but I'll let it run for a bit. And the last minute issues will come up will be that she'll actually be completely, pretty much unprepared, and nothing will have changed from the moment she walks out of the courtroom this time to the next time. And that will actually become the issue, that she's really has done nothing, or she's attempted to file things where they haven't been accepted by the court because she hasn't filed them properly because she knows nothing about what she's actually attempting to do.
I'm going to mail to you a pretrial discovery order. And essentially what it says is that the parties need to endorse witnesses within 30 days of today's date. Any motions need to be filed within 30 days of today's date.
Yeah, now here's the thing. She's standing there listening, but I don't see her writing anything down. So if a judge was speaking to me at that moment and telling me that I needed to do something within 30 days, file any motions, I would just quickly just jot down that little phrase, motions within 30 days.
Any expert witnesses need to be endorsed no later than 30 days prior to the pretrial readiness conference.
Witnesses within 30 days, jot it down.
And again, you'll be receiving a copy of that. Jose, I'll need to send you this.
So the prosecutor needs to be aware they have 14 days to respond to this notice of presentment.
They do not. I'm the one who sets those deadlines, and they do not have to do what you say.
Ubius ibi remedium.
And so
So
Somebody might make me aware of what she just said then, because I actually don't know what she just said. I assume she's using some Latin legal term, and I know many. I know many of them, but I don't know what she said then.
I see that you're currently on a summons, and your summons is continued until the next court date. If you don't show up, a warrant will be issued. Have a nice day. Thank you, Ms. Galloway.
Yeah,
Are
goodbye.
we ready to call Ms. Galloway's case? Yeah. Okay, the court call.
Okay, here we're moving on to the second hearing, so we'll get to have a look at how what I said before about how prepared she is. Hey, just to let you guys know, I watched about half of this, so some of this may be a surprise to me. I won't know what's going on because I haven't watched it yet.
7-5. Ms. Galloway appears and is coming forward. Mr. Lemieux appears on behalf of the people. Good afternoon, Ms. Galloway. The case is set.
Your Honor, I'm Zoe G. Kendrika Galloway, and I repent of all my sins, and I'm here on special appearance, not general appearance, and I reserve all rights with explicit reservation. Your Honor, does the court's record reflect that this court is in possession of my valuable negotiable instruments, being acceptances?
So, Ms. Galloway, first of all, I'm going to ask that you hold on for a moment, okay? I need to make a record. So, Mr. Lemieux appears on behalf of the people.
Okay, so, she bounds up and she's all like full of herself, and I'm going to speak and I'm first and I know what I'm doing and rah, rah, rah. She's going to just bully her way through. These narcissists, it's amazing too. This is how you know really that they're narcissists. Because when the judge puts her in a place and says, look, you calm down for a second, we have to follow a procedure. But she also uses the term to make a record. So she's being told at that time too that everything's going on the record. You'd think that one of these narcissists might actually stop and have some introspection and think within themselves, hey, I just bounded up here. I was so full of myself. I was real cocky, and I've just been, told to quiet down, and I have to follow this procedure. Maybe that's actually what I should do. No. She's not going to do that.
We are set today for trial readiness. The case is scheduled for trial on March 25th at 8 o'clock. The 3 remaining counts after the court received proof of insurance and dismissed that count are speeding 10 to 19 miles over the speed limit, driving without a license, and driving with fictitious plates. Mr. Lemieux, are the people announcing ready for trial?
People already are.
Okay. And Mr. Lemieux, have you extended an offer in this case?
We have.
Okay. And just for the record, can you just put that on the record, please?
Your Honor, how is it that this court can retain custody of all the discharge instruments being my negotiable acceptances, yet still attach charges to my physical body when discharge has already occurred?
So, Ms. Galloway, I don't know what any of that means.
Did I say before, no one on this planet knows what she means? That was just absolute gibberish. That's not even stuff that you hear from the Sovereign Citizen Handbook normally. There was no commercial code numbers or references to, their Sixth Amendment rights or whatever it is they're going for. That was just out of Whoa.
Know that you filed a number.
Already
Let's hear a bit of that.
yet still attach charges to my physical body when discharge has already occurred.
So, Ms. Galloway, I don't know what any of that means. I know that you filed a number of motions with the court.
She believes because, I don't know, look, how do I paraphrase this? Because I don't want to do it, the matter's settled and discharged and dismissed, and it's done already because I said so. I think that's the reason.
That make no sense to the court, and I don't know what any of those
Your
things
Honor, how's
mean.
it that you can draw draft instruments on an account that you control, that you have made the prosecutor and junior security interest and accommodation party on, that you
Okay,
send
so Ms.
those
Galloway,
to me?
I asked Mr.
and that you
Lemieux
do
a
not
question,
understand
and I'm
what they
waiting
are?
for him to respond to the court, so I'm going to ask that you stop interrupting. Mr. Lemieux, if you could just make a...
Yeah, you're not supposed to ask for her to stop interrupting. What you're meant to do is to direct her to stop interrupting. See, this is the problem, all of this cotton wool, nicey. You know, if these people were put in their fucking place, you know, they're grown-ass adults, they're in a court. They're not running the show. You're not the fucking boss woman. Shut the fuck up.
record for the court as to what the offer is that's been extended in this case, so it's clear to Ms. Galloway what the offer was
I guess
or is.
I'm looking at the notes, and it looks like when we tried to convey offers previously, the kind of the same thing that happened now just happened again. So I'll just convey the offer here then on the record to plead guilty to speeding 5 to 9 miles over the speed limit. But they said no.
Excuse me, but does the record reflect I do not plead guilty, but that I plead equity?
Okay, thank you, Ms. Galloway. Please stop interrupting. Everyone gets a chance to talk. Mr. Lemieux, the offer is plead to speeding 5 to 9 miles.
$7 fine, and then plead guilty to expired plates, Your Honor.
Okay, so pleading equity, obviously that would pertain to contract law, nothing to do with a criminal case involving speeding. I don't know, I wouldn't be able to help but sort of jump in there and say, if you're pleading equity, what are you saying? That you own the car that you were caught speeding in? Fucking bravo. I mean, how does that prove that you weren't speeding in the car? That's your equity argument, right?
Okay. So it sounds as though that's the offer that the people have extended. It's pretty clear, Ms. Galloway, that you're not interested in that. We are set
Actually,
for
excuse me,
trial.
but does the court's record reflect that I have accepted all presentments and offers of the court, the clerk, and the prosecutor, and I have returned them for discharge of this matter? How is it that this court can retain custody of all those acceptances yet not recognize that discharge has already occurred?
The court has custody of the acceptances. So you've received what I wrote back to tell you what it is that I wanted, and so how can this matter not be discharged after I've told you what it is that I want?
For discharge of this matter.
It's such a fucking whack job.
Prosecutor, and I have returned them for discharge of this matter. How is it that this court can retain custody of all those acceptances yet not recognize that discharge has already occurred?
So, Ms. Galloway, the only way that you are entering a plea in this case is if it happens on the record in front of the court.
Does the record
So-
reflect that I plead equity today?
So there's no such thing as pleading equity in this case based on the allegations. If you want to accept the DA's offer, you're certainly welcome to do so.
Does the record reflect
would
I
be
have
happy-
accepted and returned all presentments and offers of the prosecutor, the court, and the clerk? And
So, Ms. Galloway, the DA's office has not filed any plea paperwork with the court that you've signed and returned to the court. I've never been provided any proposed agreement between the parties in this case.
I'd be willing to bet there that, take that last sentence there, what the judge said to her, that she actually, setting aside that she's not listening to anyone else but herself, that she actually has completely no understanding or concept or grasp or anything whatsoever of what the judge just said to her. She wouldn't understand it at all, wouldn't even be able to begin. It's almost like she just she doesn't hear it. I mean, she doesn't hear any of it, but, you know.
offers of prosecutor.
I was just pulling that sentence out as an example of how disconnected with reality or you know, the procedure, the circumstance she's actually in it in at this moment. She doesn't understand it at all.
Prosecutor, the court, and the clerk. And
So, Ms. Galloway, the DA's office has not filed any plea paperwork with the court that you've signed and returned to the court. I've never been provided any proposed agreement between the parties in this case.
What's she going to
does the
say
record
now?
reflect that
Want
I
to
have
accept-
sent my plea of equity to the court, the clerk, and the prosecutor in this matter?
So,
and
Ms.
that
Galloway,
do
I have
plead
received
equity?
all of the things that you have filed in this case. They're all reflected in the court file.
Does the court
Again,
record that I did not file anything? And Your Honor, I accept your dishonor in this matter.
Okay, now here's the thing where I jump in. To say I accept your dishonour, that to me is an open disrespect or verbal, oral disrespect of the court. I accept your dishonour. The court just lied to me. Yeah, I'm the moral superior here. You've just put yourself in it. You've just cast yourself into the bowels of moral hell compared to me.
Does the record reflect I plead equity?
Okay.
And
so,
how
Ms.
is it that
Galloway,
you do not
we're set
understand
for
the-
trial?
Sorry, I meant to add there that again, I'd be reminding her of how close she was getting to spending a day in jail for direct contempt.
And on March 25th at 8 o'clock, I'm not going to go back and forth
Okay.
with you. So clearly, you're not accepting the DA's offer, which is absolutely your right. We're scheduled for jury trial on
Does the
March
record reflect I
25th
do
at
accept
8
and
o'clock.
return the DA's offer?
So the DA just explained to the court today that today is the first time that they've ever extended an offer that you have been able to listen to. If you want to accept the DA's offer, I'm happy to pass the case, have you read through some paperwork and recall the case, but plea paperwork has never been filed with this court.
Does the record reflect I hereby accept and return the prosecutor's offer for full settlement and closure of this matter?
So are you wanting to accept the DA's offer to plead guilty to speeding 5 to 9?
Yeah, she doesn't seem to want to accept or refuses to accept that the offer isn't just something that she can go, no, I don't want to be associated with any of that. I don't have a contract with. She doesn't seem to understand what the alternative to not actually negotiating and actually accepting an offer is. That if you're not actually accepting the offer and agreeing to any of it and just dismissing all of it, they're just going to go ahead and prosecute you for the charges that they were going to initially charge you with in the first place. They're not going to let go of any of them because you're not agreeing to accept some of it in exchange for getting out of the rest of it. Because consider yourself completely unanswerable to the law. That's you, babe. You know, you're just incredible, amazing, and just the sort of woman I just would, let's not go there.
Miles over the speed limit and driving with expired plates.
Does the record reflect that I accept through assent, not consent, and that I have accepted and returned all offers?
So, Ms. Galloway, your options,
the
if you
court, the
want to
clerk, and the
accept,
prosecutor.
your options, if you want to accept the DA's offer, are to plead guilty or no contest,
And what's the other option?
to proceed to trial on March 25th.
And does the record reflect that I plead equity? And if you do not, Your Honor, if you do not understand equity pleading, surely you have a duty and an obligation to.
Well, you're going to need equity. You're going to need equity in some form to pay the fines and the huge amount of trouble that you just digging yourself into.
Use yourself and place me before a judge who does understand equity pleading so that I can settle and close this matter today. Does the record reflect that I have honored your court by accepting and returning all presentments and offers, and that this matter has been fully discharged already?
So, Ms. Galloway, the matter has not been fully discharged.
Let me see how much further. Okay, we're about, 2/3 of the way through.
As I've explained
I
repeatedly,
accept your dishonor.
the DA has extended an offer
Now, that's the second time she's done it. Again, as I said, I'd be straight onto that.
for today. Do you want to accept the DA's offer today?
Does the court's record reflect that I accept by assent, not consent, and I return it in personam to the prosecutor and the judge and the clerk for full settlement and closure of this matter?
So now she's just talking in circles, just repeating the same gibberish.
Ms. Galloway, would you like to accept the DA's offer today?
Does the record reflect I already answered that question, and then I accept by assent, not consent, and I attach it to the prosecutor in personam for full settlement and closure today?
Okay, so the court's going to take that as a no. We're set for
Excuse me, does the
trial
record
on
reflect
March
that the judge is
25th at 8
obfuscating the record
o'clock.
by putting false words into the mouth of the defendant and denying the defendant due process rights?
Ms. Galloway, I'm not.
I was actually happy to hear you describe yourself as the defendant there, even if you were attempting to speak of yourself in the third person.
Not denying you any due process rights. We're set for trial. Your options are to accept the DA's offer or to proceed to trial. I'm not going to keep going in circles with you. So, Mr. Lemieux,
I accept and return trial to you in personam for full settlement and closure. Judge, I accept your dishonor in this matter for retaining custody of the negotiable instruments, yet not recognizing that discharge has already occurred. Judge, isn't it true that in accordance with the exemption of the
Oh, here we go. She's going to accuse the court of something again. This will be gold.
constitutional clause, the acceptance is the only means of payment? And that negotiable instruments must be accepted on the face of their value, and therefore
Galloway,
full
this is
settlement
not a
has been-
civil case. This is not a money case involving two parties in a contract. This is a criminal case where there are traffic offenses that have been alleged against you.
Oh, fuck.
So again, as I've indicated, if you would like to accept the DA's offer, you are absolutely free to do so. But your options then are to either plead guilty to the two charges as the people have indicated, or for you to plead no contest.
Does the record reflect I plead equity and I return all presentments and all offers to the prosecutor? And Your Honor, I know you and I both know that while this purports to be a criminal matter, it is actually a commercial
Purports to be.
in nature, right? Otherwise, a criminal matter, it is actually commercial in nature, right? Otherwise, why is there a QSIP number attached to the bonds on this case? And Your Honor, do you have a financial interest in this matter? Isn't it true that this court has already packaged?
Yeah, they always try that on, don't they? You're part of the government's secret conspiracy to strip the people of their wealth by charging them with false allegations consistently to fine them. It's just an extra form of taxation, isn't it?
Several bonds and attached and handed them off to an indentured trustee to be prepared for securitization on the open market.
Ms. Galloway, you were issued a summons in this case. You've never posted a bond, and this court has absolutely zero financial interest in this case. Mr. Lemieux, the court is going to give the people until March 20th at noon to file your proposed instructions, good faith witness list, and good faith exhibit list. The court will then give Ms. Galloway until March 24th at noon to file any proposed changes to the people's instructions, her good faith witness list, as well as her good
faith witness list. Yeah, right.
faith exhibit list. Ms. Galloway, we're set for trial on March 25th at 8 o'clock, so we'll begin with jury selection. There'll be probably about 30 members of the public here. The parties will both have an opportunity to ask questions of the potential jurors, and then ultimately we'll select a jury. The parties will have the opportunity to select a jury of 6. We'll then proceed to opening statements. The people will then have an opportunity to present any of their evidence. You will have the opportunity to ask questions of any of their witnesses. You'll then have the opportunity to testify yourself, present any witnesses or evidence that you have, and then both sides will have an opportunity to make a closing statement. Do you have any questions generally about how the trial will proceed, or any basic trial procedure questions that I can answer for you?
Does the record reflect that I employ my equitable right of rescission and rescission anything that I may have unknowingly acquiesced to in this matter, and that I do indeed plead equity?
Classic. Okay, so what did she say there? That reserve her rights and anything that she may have unknowingly acquiesced to. I actually think she's not properly understanding acquiesced or misspoke there. So much as acquiesced implies that it was something that, she unknowingly agreed to, or agreed to do because she doesn't want to agree to it to anything. But I think actually what she meant was unknowingly confessed or admitted to anything. That's what she really meant. Yeah, I don't agree to anything, and I don't confess to anything. That's what she's, and of course, she's trying to claim this right that nothing that she said in court or on record is going to be used against her. Well, yeah, you'd be pretty much 115% wrong about that one, love.
Questions that I can answer for you.
Does the record reflect I employ my equitable right of rescission and rescission anything that I may have unknowingly acquiesced to in this matter, and that I do indeed plead equity, and that I accept your dishonor and attach trial to you in personam for full settlement and closure of this matter?
Again, Ms. Galloway, I don't know what any of that means. None of those words are criminal terms that are in the...
It sounded like a personal threat to the judge. It sounded like a personal threat to you personally, herself. But in nothing that's actual, just in her smug, I can get you, I'm big, I'm better, I'll even come after you because no one can stop me because I'm fucking right about everything, because I'm, what was it again, the most narcissistic, entitled, arrogant, fucking annoying Karen that's, been born so far on the planet ever.
Statutes or the Constitution of the Colorado Constitution or the federal Constitution. There's no option to plead equity. I don't know what you're referring to. I've explained to you repeatedly what your options are. So at this point, I've imposed deadlines for trial.
Does the record
We'll
reflect
see you
I
back
plead
here
equity, and the
on
judge
March
is obfuscating the
25th.
record by entering a false plea on behalf of that defendant? And your judge, if you do not understand the negotiable instruments laws of the state of Colorado, the United States of America, and the accounting on this matter, surely you have a duty to recuse yourself of this matter so that I can be put before a judge who does understand equity, so that I can settle and close this matter and bring full honor to your court.
So, Ms.
Oh my Lord. There's just, I've used the term narcissist numerous times in this video, but to hear that, you're dishonourable, Your Honour, and I will bring honour to your court.
You have a duty to recuse yourself of this matter so that I can be put...
Yeah, recuse yourself. You go feel the shame of attempting to even think that you should judge me at all. Recuse yourself, and it will restore honour upon the court.
Before a judge who does understand equity so that I can settle and close this matter and bring full honor to your court.
So, Ms. Galloway, as I've referred to you repeatedly, as I've explained
Fucking insane. You are insane.
repeatedly, this is not a civil case. There is no money. There's no negotiable contracts.
Your Honor, are you trying to overturn hundreds of years of an equity jurisprudence?
With the court. The court is following the procedures required of me, so we'll see you back here on March 25th at 8 o'clock for jury trial. Thank you.
I accept
The
your
court is in
dishonor and I return it
recess
back
in
to
this
you in
case.
personam for full settlement and
Ms. Galloway, the court's in recess on this case. We'll see you for trial on March 25th at 8 o'clock.
As I said, if she had been carted off now and was spending 24 hours in prison for direct contempt, I'd be willing to bet that the next time she came back to court the next day to appear for that contempt hearing, yeah, her smugness, her attitude, yeah, that would fucking calm down a lot for sure. I'd be willing to bet.